Good afternoon. First of all, I would like to extend my sincere gratitude to Dr. Nauman Reayat, founder of the Global South Network and the University of Leicester, for providing me with the opportunity to react to the insightful talk by Lord Reed. I would also like to sincerely thank Lord Reed for his enlightening and interesting talk. It is an honor and privilege to offer a few reflections on this crucial subject, particularly from the perspective of a small island nation like the Maldives. Lord Reed emphasizes the importance of judicial cooperation in addressing global challenges that transcend borders. I believe these challenges include judicial independence, fundamental rights protection, climate justice, and transnational crime. The need for collaboration between the Global North and the Global South is more pressing than ever. North-South judicial cooperation resonates deeply with us in the Maldives, a nation uniquely positioned at the intersection of vulnerabilities and opportunities. For those unfamiliar with the Maldives, our judicial system comprises a three-tier structure: the Supreme Court, the High Court, and the First Instance Superior and Lower Courts, which are scattered over 180 islands. The Supreme Court serves as the final authority on the interpretation of the Constitution, the law, or any other matter dealt with by a court of law. The Supreme Court has original jurisdiction in matters such as parliamentary disqualification, presidential elections or removal, and states of emergency. It also holds inherent jurisdiction over disputes which may result in a constitutional void in the country, disputes between two powers of the state over the interpretation of the Constitution, and public interest constitutional issues. Additionally, the court has advisory jurisdiction where Parliament may request its opinions on significant legal or constitutional questions. While the Maldives follows a legal system significantly influenced by common law, the insights shared by courts in the Global North, including the UK Supreme Court, have often provided guidance in areas such as constitutional interpretation, human rights, and trade-related laws. When interpreting fundamental rights, our Constitution stipulates that our interpretations are aligned with best practices of democratic nations. This demonstrates how cross-jurisdictional exchanges can enrich and strengthen our domestic jurisprudence. The Maldives judiciary exhibits success stories from Global North partnerships and collaborations. I would like to highlight the long-standing relationship between the Maldivian judiciary and the UK. I would like to express my heartfelt gratitude to the UK government for the various partnerships with our judiciary in strengthening family justice, civil justice, and criminal justice by assisting us in the development of policies and procedures. Professional development programs for judges and employees of the judiciary, need-based effort on digitalization, public outreach programs, and women in judiciary are just a few projects supported by the UK government. Ongoing projects include working with the criminal justice system, including judicial mentoring that will bring meaningful outcomes by addressing emerging challenges. Judges from the UK made significant contributions in some of these projects. For courts in the Global South, including those in the Maldives, such exchanges are invaluable. Capacity building initiatives, judicial training programs, and collaborative analysis of case law can address resource disparities and enhance access to global legal resources. Equally, it is crucial for the Global North to acknowledge and learn from the local knowledge and traditions of the Global South, enriching global legal discourse. Achieving this requires constitutional and Supreme Courts to identify shared goals and areas of mutual interest, prioritize them, and establish partnership for cooperation. While I appreciate the fact that the UK judiciary is actively engaged in collaborations with other judiciaries from around the world, areas for judicial collaboration between the Global North and South are endless. Research and development could be focused as an area of cooperation between courts of the Global North and South, as this shapes all other areas of collaboration. Courts can strengthen judicial capacity, enhance knowledge sharing, and address shared challenges. They can jointly conduct research on key issues like judicial independence, case backlog reduction, and access to justice, publishing collaborative reports that reflect shared insights. Regular interaction between judicial academies, participation in international forums, and mentorship programs can facilitate capacity building and skill development. Collaborative initiatives may also include internships and academic exchanges for judicial clerks and law students, fostering global legal exposure. Additionally, providing technical assistance, e-learning platforms, and access to legal databases supports judicial education, particularly in the Global South, enhancing the overall effectiveness of justice systems. Judicial cooperation must respect the autonomy and diversity of legal systems. For countries like the Maldives, preserving our unique legal identity is essential while engaging in collaborative efforts. Mutual respect and a shared commitment to justice are key to successful cooperation. In conclusion, Lord Reed's talk highlights the significant opportunities judicial cooperation offers in addressing shared challenges and promoting global justice. The Global South Network could provide a platform for meaningful dialogue and collaboration, fostering efforts to build a more equitable and resilient legal landscape through continued engagement between the Global North and South. Thank you.
Thank you very much. Thank you very much, Honourable Justice Dr. Azmiralda Zahir, the Supreme Court of the Maldives, for your response. I must say, she is severely ill and still she is able to deliver the response. Is commendable.